Hi, everyone. Thank you for being here to to join us for this really important and for me fascinating topic. When I was asked to moderate this panel, I wanted to say no, but I can't do that. So we have three amazing speakers here today. I'll introduce them to you now. Our first speaker, Karnig Kerkonian, is a seasoned international lawyer and experienced litigator. He's a founding partner of Kerkonian Dajani LLP. Mr. Kerkonian regularly handles litigation and appeals covering a range of subjects, including foreign sovereign immunity, international business contracts, fiduciary duties, statutory and tort claims, often involving multinational commercial entities and/or foreign states. He currently leads the international and federal practice groups at Kerkonian Dajani LLP, focusing on complex litigation matters, Foreign Sovereign Immunities Act litigation, and Alien Tort Claims Act and commercial sanctions regime matters. Mr. Kerkonian is also an adjunct professor of public international law at Artsakh State University. He is likewise active in public interest matters involving international human rights issues. He presents regularly on matters of public international law, the International Court of Justice, the European Court of Human Rights, and the application of international law in U.S. courts. He'll be joining us virtually. Sadly, he couldn't be in Yerevan with us today. Our second speaker is Dr. Sarah Babaian, jurist, international negotiation expert, and conflict manager. She completed her law degree at the University of Hamburg and further qualified as a business mediator. She then pursued a Master of Advanced Studies at the Geneva Academy of International Humanitarian Law and Human Rights, following which she completed her PhD in International Criminal Law at the University of Hamburg. Dr. Babaian's professional career has included work at the UN Office of the High Commissioner for Human Rights in Geneva, as well as the European Center for Constitutional and Human Rights, and other law firms and companies. Dr. Babaian regularly lectures on various topics of international law and negotiation at universities and advises international companies as well as states, political actors, international institutions, and NGOs as a professional negotiation expert. She is a member of the German Armenian Lawyers Association, and together with two other members of the association, she's the publisher of the book Nagorno-Karabakh, a judicial analysis of the conflict concerning Artsakh. Our third speaker, Eric David, is a professor of international law at the Université Libre de Bruxelles, where he has been professor emeritus since October 2009. All of Professor David's courses have been published. His Principes de droit des conflits armés have been translated into Russian. His course syllabus on public international law is updated and published each year at the Presse Universitaire de Bruxelles. Professor David practiced international law as counsel for various states before the International Court of Justice. He was a member of the International Humanitarian Fact-Finding Mission from 2007 to 2017, and has conducted investigations into violations of human rights and international humanitarian law in the occupied Palestinian territories for the International Association of Democratic Lawyers, in Rwanda for Amnesty International, and in the Philippines for Geneva Call. Please join me in welcoming our distinguished panelists. Karnig, you have the floor.
Thank you so much, Sheila, and thank you to the CFTJ for the opportunity to join you. My regrets for not being able to be there with you in person. It was a pleasure, I'm sure the audience agrees, to have the opportunity to listen to Dr. Giragosyan's presentation, because his leadership at the ICJ truly has been historic. You know, the title of this panel has some phrases that are loaded with weight and emotion for our Armenian people: self-determination, resilience, human rights, struggle. Each of them has at its core some normative power, one that governs perceptions of who we are as a nation, of our national consciousness, indeed our dignity. Now, beneath each of these valuable tenets of international law, a framework of teleological concepts, rights, and commitments form a lattice of rules and behavior that we and every other nation aspire to understand and find our place within that normative plane of right and wrong. For us, however, these concepts of international law, self-determination, human rights, and even sovereignty are tactile. We feel them, and they feed our narratives, our own, our adversaries, and they shape our place in the future of the world order, one which should be based on the rule of law and the rule of international law, if you will. And what I want to do today, then, in the 20 minutes that I have, is briefly discuss three false narratives, three empty myths that we've allowed to infiltrate the international law discourse on what I consider to be the most crucial front in our nation's struggle, and that is Artsakh. These are false narratives that collapse miserably under any serious international law analysis, but they are narratives that we have allowed to occupy space. And this is something that Yerevan mentioned a moment ago, kind of the gaps that were left open, the gaps that are being filled by some of the narratives of our adversaries. And they occupy space in the discourse concerning specifically the right of self-determination in the most vital corner of the Armenian world. The first myth I'd like to discuss is this: Artsakh is part of Azerbaijan. Historically, the works of Strabo, Ptolemy, Plutarch, Dio Cassius, and others, the ancient Greeks and the Romans, if you will, all describe Artsakh as uniquely Armenian. And I bring up the ancients because it stands in sharp contrast to the rather slapdash creation of Azerbaijan. And it's important because, let's be clear, even after the fall of the Transcaucasian Federation in 1918 and Azerbaijan's first declaration of independence, it was somewhat of a dead state. In December 1920, Azerbaijan was not even recognized as a state by the League of Nations, despite applying for membership, and let alone did anybody recognize its Turkish-supported claims to Artsakh. In fact, its application to the League of Nations was outright rejected. And I want to read something from that December 1st, 1920 rejection statement from the League of Nations, because it's interesting. It says, and I quote, "Azerbaijan cannot be regarded as de jure a full self-governing state, as it has not been recognized de jure by any member of the League of Nations. It is difficult to ascertain the exact limits of the territory within which the government of Azerbaijan exercises its authority. Owing to the disputes with neighboring states concerning its frontiers," the League goes on, "it is not possible to determine precisely the present frontiers of Azerbaijan." Azerbaijan was not a recognized state by the League of Nations in 1920, and shortly thereafter, of course, the Soviet Republic of Azerbaijan was created, complete with Stalin's territorial gamesmanship. I'm not going to go into that, but for a good reason, and that's because it doesn't matter so much. Azerbaijan's 1991 rejection of its Soviet legal heritage as illegal and the reinstatement of its 1918-1920 state, which nobody recognized, and which clearly did not recognize as Artsakh within its borders, is a historical point with important legal implications, which frankly, we have left on the table. These are those spaces, those voids. Constitutionally for Azerbaijan, they are the predecessors of their 1918 independent and unrecognized entity, with all that Soviet heritage that happened in the middle being declared illegal and of no effect. This means something. Sloppy state creation, perhaps, but with actual legal consequences. Artsakh has never been part of the Republic of Azerbaijan in international law. It can't be. The math doesn't add up. Azerbaijan's own math doesn't add up. The legal steps are disconnected, disjointed, and simply do not connect the legal dots. But even if we were to set aside these crucial gaps in historical and legal lineage's niceties, international law today has moved well beyond the time when a tyrant could pound the life out of a population. And this leads me to my next myth. And it's a myth that is predominantly has spread throughout social media in the aftermath of this war as well. Myth 2 is that Kosovo is an exception. It's not precedent. As Dr. Giragosyan alluded to earlier, in Kosovo, the ICJ determined that Kosovo's unilateral declaration of independence was legal giving rise to the concept of remedial secession, remedial self-determination. But the question is Kosovo really an exception? Simply saying that Kosovo establishes no precedent doesn't quite make it so, because that's not how international law works. International law is established, among other things, through state practice, not convenient political expedience. And where did this Kosovo is an exception, Kosovo is not precedent rhetoric come from? I recall Condoleezza Rice, the US Secretary of State, who said in 28, and I'm going to quote her here, "The unusual combination of factors found in the Kosovo situation, including the context of Yugoslavia's breakup, the history of ethnic cleansing and crimes against civilians in Kosovo, the extended period of UN administration, are not found elsewhere, and therefore make Kosovo a special case." She added that because of this uniqueness, the independence of Kosovo cannot be seen as precedent for any other situation in the world today. Now, that description does not sound quite so unique to me. In fact, not at all. It actually sounds a lot like another situation we've heard of. But the question is, what has been the practice of states in the aftermath of Kosovo? Just months later, in 2008, Russia reinforced the secession of Southern Ossetia and Abkhazia from Georgia, using principles that sound an awful lot like Kosovo. Russian President Medvedev in 2008 said that, and I'm quoting here, "A decision needs to be taken based on the situation on the ground." And he referred to the freely expressed will of the Ossetian Abkhaz peoples and the UN Charter, the 1970 Declaration on the Principles of International Law, and of course, the Helsinki Final Act of 1975 in recognizing South Ossetia's and Abkhazia's independence. His reasoning, however, was quite Kosovo-esque, if I may. He said, "This is not an easy choice to make, but it represents the only possibility to save human lives." He went on, specifically referring to Kosovo, and saying, "We argued consistently that it would be impossible after Kosovo, he means, to tell Abkhazians and Ossetians and dozens of other groups around the world that what was good for the Kosovo Albanians was not good for them. In international relations," he said, "you cannot have one rule for some and another rule for others." And indeed, that does sound like what a rule is. Russia used Kosovo's remedial language in Crimea as well. Russian President Putin said that, quote, "The people on the peninsula have freely chosen to belong to Russia. The government in Kiev has nothing to counter this clear and unequivocal will of the people, and therefore relies on aggressive actions, on activating extremist cells, including radical Islamic organizations." This sounds quite familiar too. My interest here is not the politics of the matters. It is the legal justifications afforded the state conduct in question. And President Putin continued, as for the situation in the Donbass, saying that, "We see that the leadership in Kiev is constantly stating publicly they are not ready to implement the Minsk package of measures to settle the conflict, and they're not interested in a peaceful resolution. On the contrary," Mr. Putin said, "that they are once again trying to organize a blitzkrieg in the Donbass, as they did in 2014 and 2015. He said, now practically not a day goes by without shelling of towns and villages in the Donbass. A large group of troops constantly uses attack drones, heavy equipment, rockets, artillery, and multiple rocket launchers basic rights to live in their own country, to speak their own language, to preserve their culture and traditions." Again, my interest here is not any political assessment. There are plenty of pundits to talk about the politics of the Ukraine conflict. I'm focusing on the legal justifications afforded the state conduct in question. The reason for recognition given by Russia is the same reason given by NATO for the recognition of Kosovo. It is remedial. In fact, what we have today are two competing world blocs employing the very same principle. Kosovo is not an exception. Kosovo is the rule. And this leads to the third myth, which I find to be the most dangerous of all. And that myth is that self-determination and territorial integrity are competing rights. In my opinion, this is the most intellectually sloppy discourse of all, and the fact that it has gained any currency whatsoever is absolutely astounding. Other scholars, Tom Samuelian, noted this myth over a decade ago, and Sean Avakian alluded to it before the four-day war in 2016. There's no proper counterbalancing between the right of self-determination and the concept of territorial integrity. This is what the Kosovo case was about, and this is why it was so important. It separated the two and allowed legal thinking to enter the fray. And what it teaches is this: even if Azerbaijan had some legally sound claim of sovereignty over Artsakh, which it does not, Artsakh's right to self-determination would prevail anyway. And here's why. In Kosovo, the ICJ explained that territorial integrity is a principle confined to the relations between states. It is not a separate right that can be legally counterbalanced against the right of self-determination. It's an instrumental nicety, not a substantive norm of international law. There is no equipoise. One is substantive international law, the other is an instrumental rule, something of international relations among states. It is a rule of reciprocal conduct in relations among states. It's not a right under international law. In fact, territorial integrity is an attribute of sovereignty. It is a derivative attribute. It is something that comes from sovereignty. And sovereignty itself is not an absolute right. It is contingent. It is a contingent right that accrues to a state over a population or territory based on that state's ability to fulfill certain duties and obligations. You know, the big ones: life, liberty, security, identity. When a sovereign fails in its duties, the remedy in international law is self-determination. Frankly, this legal underpinning can be traced in international law theoretical analysis, even political theory, from at least the time of the French and American revolutions, through European anti-autocratic movements, through decolonization, and indeed through Kosovo and even the Donbass, as politically unpopular as that truth may be today. Sovereignty ends where the right of and remedy of self-determination begins. Where a sovereign state is unable to fulfill its duties to a population and territory, the polite courtesy of respect for territorial integrity ceases. States do not need to continue respecting the territorial integrity of a sovereign that has failed in its duties to protect life, security, safety, and existence of a population. You know, this is why it feels wrong to us when territorial integrity is flaunted as some absolute right under international law before which we must be forced to kneel. It feels wrong because it is wrong. Azerbaijan has failed when it comes to protecting the rights to life, security, and safety of Armenians. It would be categorically immoral to use a human population as a let's give it another try experiment for Turkish and Azeri governance over Armenians, you know, for the sake of territorial integrity, some reciprocal nicety between states and their relations. History is quite telling of Turkey and Azerbaijan's failure to fulfill sovereign duties with respect to Armenians for over a century at least. There's no rational basis to conclude that they're capable of fulfilling those sovereign duties now. Even in the aftermath of the last war, it is conquest and cleansing that we hear from Baku, nothing else. Human beings who have exercised the legal right of self-determination, indeed self-governance, should not be the experimental guinea pigs for giving Azerbaijan another bite at the apple at governance for the sake of territorial integrity. That has it backwards. It turns international law on its head. The sheer perversion of this faulty legal equipoise is evident from even a simple theoretical exercise. Territorial integrity is an attribute of sovereignty, and sovereignty itself is derivative, especially in Western liberal discourse, from the right of self-determination. That begs the question, if territorial integrity were of original primacy under international law, where would sovereignty and self-determination actually come from? Would you argue that sovereignty and self-determination come from the concept of territorial integrity? You know, you wouldn't. You couldn't because it would make no sense. It only works the other way around. Self-determination is the normative right at international law, not territorial integrity. It doesn't make sense any other way. And allowing the discourse of legal equipoise between self-determination and territorial integrity is not only bankrupt, but it's also careless and sloppy international law. The geopolitics, the military threats, the cultural devastation, the security risks are serious and existential enough for our people. We owe it to ourselves, especially as lawyers, to at least get the law right. And perhaps by getting the international law on self-determination right with respect to Artsakh, we may yet have a historic chance to reclaim a narrative that has really run away.
Thank you, Karnig. I was so busy writing up all my notes for questions I'm going to have. I might become a co-panelist. I'll try not to. But the floor is Dr. Babaian's.
Yeah, thank you very much. I'm very honored to speak here today on the subject of Nagorno-Karabakh and the right of peoples to self-determination versus territorial integrity. Thank you also to the panelists before. It was very interesting to listen to this. I think we come to the same conclusion, but maybe slightly by a different way. Even though the principle of the right of self-determination with its strongest form of secession from the secession is mentioned so often, I think that most of the people are not really aware of how the claim of the right really arises and why states actually do not have to be fearful of that concept. This analysis of international law is based on balancing of the universally applicable principles of the right of self-determination of peoples on the one hand, and the sovereignty of states on the other hand. And maybe to say that, maybe that's, as the panels before said, not a right, but it's a fundamental norm in international law. So as you are all experts now with regard to the history concerning Karabakh, I do not want to bother you anymore with so much more information. But what has to be said once more is that it was never planned to annex Nagorno-Karabakh into the Azerbaijani SSR. So on the contrary, 1920, Stalin reaffirmed that Artsakh has to be integrated into Armenia. But as always, plans are made and then politics comes into the room. So the relationship to Turkey and Azerbaijan was quite more important for Stalin. And so in the end, Artsakh ended up in as an autonomous region in the Azerbaijani SSR. So you know too well what has happened the past 100 years, but especially in 2020. So the Third War, with all its consequences, once again demonstrated how essential it is to clarify the legality of a possible cessation of Nagorno-Karabakh in order to finally bring about a peaceful, but first and foremost, a lasting solution. So let us have a look into the right of self-determination. What is the right to self-determination? It says in the Friendly Relation Declaration that by virtue of the principle of equal rights and self-determination of peoples enshrined in the Charter of the United Nations, all peoples have the right to freely determine, without external interference, their political status and to pursue their economic, social, and cultural development. And every state has the duty to respect this right in accordance with the provisions of the Charter. The establishment of a sovereign and independent state, the free association or integration with an independent state, or the emergence into any other political status freely determined by a people constitute modes of implementing the right of self-determination by these people. So what are the possibilities of self-determination? It is, first of all, the establishment of a sovereign and independent state. Secondly, it could be the free association with an independent state, or the free incorporation into such a state. But what are really the requirements, or what is the scope of the right to self-determination? It consists of a three-stage step. So the internal and external right to self-determination have to be distinguished. They are in a kind of gradual relationship, which means that since the external right to self-determination only applies insofar as the internal right of self-determination has been withheld by the people. So what is the internal right of self-determination? The internal right of self-determination covers not only the right to determine the political form of government, but also the right to exert influence and freely determine and decide on its cultural development. Modalities of self-determinations are various models like autonomy, federal state structures, sufficient participation of all peoples in a democratically constituted state system. If, and in addition, and this is very important here for our case, the people are claiming self-determination are an ethnic minority, it can exert defensive internal self-determination. We will talk about that a bit later. So it is only when this autonomy has been denied that inner self-determination strengthens out into external self-determination. This is very, very important to know, and very important for all states, because this is not just external self-determination which comes out if you apply self-determination. So the outer, external, offensive right to self-determination only comes into play when the possibilities of the internal, such as autonomy models or federal state structures, have been denied. So if the external self-determination is applicable, the choice of internal political status of the people can be accompanied by a change in territorial borders. And here everyone is shaking and everyone is getting afraid. Why? Because it becomes clear that in the change in territorial status resulting from the right of secession, that this could contradict to the concept of the norm of the territorial inviolability of states. Furthermore, the people who are invoking the self-determination right have to be holders of the right to self-determination. So consequently constitute a people in the sense of the right of self-determination. So let us look directly into what is going on with regard to Artsakh. So it's the internal right to self-determination. So as we said, we have to see to what extent the Armenians in Nagorno-Karabakh were granted the right or not granted the right to internal self-determination. So the very important question is, was there ever an autonomy status? As we know, the original decision on territorial autonomy was never implemented in the 1920s. The Azerbaijani laws granted rights only to Azerbaijani government. Armenians were not even present in the Council of Ministers. The Armenian language has been mentioned less and less over the years. Despite petitions and letters in 27, 29, 35, 44, 63, 67, 77, and 88, and sorry for reading them out, but this really shows the concept that the people always said that here something is going on. The internal self-determination is not existing. So through all the petitions, they try to say that this is not applied. But all attempts to draw attention to this oppression have failed, as we know. And after the proclamation of the Republic of Nagorno-Karabakh in 91 and 92, Azerbaijan even revoked the autonomy altogether. So the question is, was there ever an autonomy status? Of course, no. It was just a fictitious autonomy status. And the further question is, next to the question of fictitious autonomy, I don't know what has happened there. It's the question if the respect for fundamental and human rights were given. But as we know, unfortunately, the government systematically discriminated the people of Artsakh since 1920. School subjects cancelled, school textbooks in Armenian language prohibited, around 120 churches closed, clergy imprisoned, intellectuals banned, villages disappeared and banished, and the Sumgayit massacre in 98 through killings, torture, and rape. And then not to forget the Operation Ring, which was already condemned as genocide. And then last but not least, all the incidents happened in the second and third wars, 2016 and 20, where Azerbaijan is responsible for the commitment of mass human rights violations. So we can say in the end that there is, I don't know what's going on, that there is no respect for human rights, and that there is a mass ethnic discrimination. So behind the facade of granting autonomy was a policy of discrimination to carry out an Azerbaijanization, and to even say it even harder, the annihilation of the Armenians. It can be concluded that on part of the Azerbaijan, there has been a gross violation of the internal right of self-determination, above all, the suppression of political, cultural, religious, and physical rights. In particular, the population of Nagorno-Karabakh should have been entitled to minority and human rights protection, as they fulfilled a distinct peculiarity of a people within the Muslim country. So as can be seen, Azerbaijan never granted the people of Artsakh internal self-determination, so that internal self-determination turns into external self-determination. And this can also have a change in territorial borders. So this internal political status of the people can lead to this change of borders because of, because of what was happened the last 100 years. And one also has to say, and I think also the panels before said it totally correct, it must be noted that it would reduce the right of self-determination absurd if a people had to remain within the borders of a state, even if this state seriously violates the right to internal self-determination of its people. So the third requirement for the right to self-determination is the concept of the Bureau of the Right to Self-Determination. And this is always divided into objective and subjective criteria. I don't want to jump to it too extensively because we don't have so much time, but the concept of a nation can be understood on the one hand from a very legal, very political and geographical perspective. And then on the other hand, in terms of certain similarities, such as the language, the mentality, the culture, historical ties, and religion. And I think it's indisputable that the Armenians of Nagorno-Karabakh constitute a people in the meaning of the right to self-determination. So, in summary, we can say the ethnic group of the Armenians in Nagorno-Karabakh is the bearer of the right to self-determination. They were denied the exercise of internal self-determination because the autonomy status did not only exist, it was intentionally undermined by means of eliminating the Armenians and everything with them. So the inner self-determination turns into an external self-determination from its in its utmost form of secession. So in principle, we could say and conclude, the Armenian population in Nagorno-Karabakh has the right to establish a sovereign and independent state, or to be incorporated in the already existing state of Armenia. So I could finish here, that would be nice, but as we know, there is a problem because there is the concept of the territorial integrity. Even if we don't call it a right, it's a very fundamental norm in international law. So the Republic of Azerbaijan is invoking its territorial integrity. And territorial integrity, as I said, is one of the most fundamental norms in international law, and also a cornerstone and pillar in the United Nations Charter. It is mentioned in the Charter and treaties, but most expressively in the Helsinki Final Act, and says the following. The participating states regard as inviolable all one another's frontiers, as well as the frontiers of all states in Europe, and therefore they will refrain now and in the future from assaulting these frontiers. The participating states will respect the territorial integrity of each of the participating states. Accordingly, they will refrain from any action inconsistent with the purposes and principles of the Charter of the United Nations against the territorial integrity, political independence, or the unity of any participating states, and in particular from any such action constituting a threat or use of force. So in the past, the territorial integrity was seen as an absolute and permanent power, whereas today it is more understood as an internally supreme power and externally independence. But sovereignty has or finds its limits also in the right to self-determination and in the prohibition of violence and intervention. So, as can be seen, the right to self-determination and the state sovereignty are in a great disproportion or tension. So it has to be determined which right has to, or which concept, because I like what Mr. Kerkonian said before, it is maybe not a right, it's a concept, it has to withdraw behind the other. So in between the practical concordance, the question is to bring both norms of international law to a justifiable balance by means of practical concordance. So, as we already said, the territorial integrity is one of the most fundamental principles in international law. This is also the reason why many grant absolute priority to the right of, or to the sovereignty, arguing in international law guarantees state sovereignty, and therefore the right of self-determination has to take a backseat. Furthermore, the solution of inner-state conflict should be first and foremost in the responsibility of the rights of the state concerned, which is good in principle. Firstly, of course, this is intended to counteract the fragmentation of states, which is also understandable. In addition, the softening of this principle could be a go for abusive efforts by third actors, and separatists could use force to achieve their goals. The secession, on the other hand, as the strongest form of self-determination, intervenes precisely in these firmly existing structures and can change the existing borders of one or more states. Oh, sorry. But it must also be said that an interpretation to the effect that the people must remain within the borders of a state, even if this state has seriously violated the right to internal self-determination of its people, would completely nullify the right to self-determination and render it void. A state authority that functions only as an oppression apparatus can hardly invoke its sovereignty with the argument of stability and thereby argue that secession poses a threat to peace. In such a case, it must be particularly emphasized that the concrete will of the utmost form of self-determination only arises from the state's disregard for any interest of the community and human rights. So once again, it is the duty of the state concerned to prevent the secessionist aspirations of people as the most serious consequence of external self-determination by granting internal self-determination. And sorry to bother you or to repeat myself, but once again, the state in question can decide whether or not such a secession takes place. Respect for internal self-determination is an extremely important, but above all, fundamental practical means of diffusing conflicts between different ethnic groups within a state by offering political autonomy solutions to these ethnic groups, asking for change. If the will of the people is taken on a basis, such secessionist aspirations cannot even arise. So, as has been examined, the Armenian population of Nagorno-Karabakh has been denied internal self-determination from its very beginning on. The people were exposed to terrible human rights violations and discriminations for 100 years by Azerbaijan. The exercise of self-determination then represents a right to self-defense, remedial secession, as Mr. Robertson yesterday truly said, through which secession can be justified. Because only by the means of the applicability of the right to self-determination, it is possible for the people of Nagorno-Karabakh to preserve their human rights, to counteract further serious violations, and to make use of their self-determination. And thus, it can be established that the Armenians of Nagorno-Karabakh are entitled to right of secession under international law, in addition to right, and we don't have the time for that now, but I think you're quite clear on that matter, also a secession under domestic law of the secession of the UdSSR right. So it can be stated that in this individual case of Nagorno-Karabakh, Azerbaijan may not exercise its sovereignty unconditionally. Azerbaijan may not exercise its sovereignty unconditionally, and its right to sovereignty must therefore take a back seat. Oh, sorry. I'm too fast. Must take a back seat to Nagorno-Karabakh's right to self-determination from the secession, which will prevail in this case. But as the
Dr.
headline...
Babaian, you have 1 minute.
Yes, give me 2. Perfect. But as the headline of my presentation already stated, the clash between law and politics, I was talking now in my role as a legal advisor. Now I am talking in my role as a negotiation expert. And as we know, the right to self-determination could still not be implemented as we like to have it, because the territorial integrity is still the prevailing force. Diplomatic efforts were not really pushing for the implementation of that right, as the states are so frightened of of granting this right. The work of the OSZE did not lead to any kind of results. No one is really interested in this process, or better to say, is too interested. The fact that Nagorno-Karabakh is not even seen as a party to the conflict and not even invited makes it even worse. And the further ceasefire agreement that Pashinyan must really have made under a Capone manner, like I make you an offer you cannot refuse, doesn't even mention the status in one word. The current peace efforts are concerned with many things except of the status, and bad rumors are circulating behind closed doors. So the headline of the presentation once more is the clash between law and politics. And it happens all in an exclusively political environment. So we cannot neglect or disregard politics and just argue with legal principles. But as a very famous Italian criminal lawyer, Carrara, once said, if politics comes in by the door, justice is thrown out of the window. But I would like to change that. If politics comes in by the door, justice is reaching out its hand and throws politics out of the window. Thank you very much.
Thank you, Dr. Babaian, especially for taking actually those two. I have a very hard job as a moderator, and I know that you've probably practiced at length. Eric, Professor David, the floor is yours if you'd like to get up. Thank you.
Thank you for inviting me at this conference, and congratulations to the organizers for the perfect organization of this conference. I've been asked to present the problem of self-determination, but I think that much has been already said. Is it possible to have my outline on the screen? I sent it a few weeks ago already. It will be easier for you to send my presentation. Otherwise, I get it on a USB key if you prefer. There is the one with the red tag. Yes.
We're going to get the computer up there for you.
Well, but it's possible, of course, to use the computer which is in front of me, if you like. But so I have to get my USB key back in order to put the USB key in your computer.
I think they're working on it. Is there any way you can get started before you have it up?
Sorry?
Is there any way you can get started before you have it up? They should have it up in a minute.
You are going to have it?
Yeah,
Yes?
yeah, yeah.
Okay,
Just in a minute.
I can wait.
Okay.
But, well, in fact, I can start. There is no problem about that. And in fact, my presentation will be divided into two parts. During the first part, I'm to show that self-determination of peoples is the right of peoples to self-determination is merely confined to colonial and para-colonial situations. And the second part will be dedicated to the fact that there is an evolution today in this perception of the right of self-determination. I'm sorry that I'm going to repeat some things which have already been said by the previous speakers, even if I'm not going exactly in the same direction. As you know, the principle of self-determination appears already in the UN Charter, in Article 1 of the UN Charter, Article 1, Paragraph 2. Oh, wonderful. You get it. So you can see that one of the purposes of the of the UN Charter is to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples. So the source of the right is clearly established already in the UN Charter, but in fact, the real codification of the principle will be found merely in resolution, if you can go a little further, in resolution 1514, the famous resolution on the declaration of independence of states. And in this resolution, it's a little bit further. You can go down with the it's not a real PowerPoint presentation, because I can't succeed to dominate a PowerPoint presentation. I have each time that I use that system, I have only one fancy is to throw my computer through the window. So in order to spare my computer, I don't use a real PowerPoint presentation. Sorry. So in resolution 1514, which was adopted by the General Assembly in 1960, as you see in paragraph 2, it's stated that all peoples have the right to self-determination. By virtue of their right, they freely determine their political status and freely pursue their economic, social, and cultural development. It's something which is well known, and you find the same principle in always, if we follow the sources of the principle, in Common Article 1 of the 1966 Human Rights Covenants, which say that all people, I quote, all peoples have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. Once that we have seen that the principle is clearly established in international law, we have to define the notion of people. Which are the people who are the holder of this principle? According to resolution, once more you have to go a little down. Exactly, thank you. You have a definition of people which is, I may say, a generic definition and a specific definition. The generic definition, you find it in resolution 1541. It's the contrary of 1514, and which states that a people is the people who are entitled to use the principle of self-determination are peoples who are on a territory which is geographically separate and is distinct ethnically and or culturally from the country administrating it. And the fifth principle say that if they affect the relationship between the metropolitan state and the territory concerned in a manner which arbitrarily places the latter in a position of status of subordination, they support the presumption that there is an obligation to transmit information under Article 73, little e of the Charter. And so there you have this famous declaration in the UN Charter in Article 73, which is not at all an article which provides for independence of people having the right of self-determination, but which just obliges states to give information about the way they lead these countries that they administer, how they lead these countries to progress for a kind of autonomous administration. And on the basis of this article, if you can, yeah, let's go, thank you. The UN Secretary General in 1946 asked all states to specify which territories, which are non-self-governing territories, for which they have to give information according to Article 73 of the UN Charter. And it was this list of territories that you have the list here. And today, if we look at this list, you have 17 non-self-governing territories which are listed on the list. And you have, in fact, you see that it's mainly colonial or para-colonial situation. What I call para-colonial situations, it's situation like the Western Sahara situation or the Palestine situation, which are not exactly colonial situation, but what I call para-colonial situation. Well, unfortunately, in all these, in this list, you don't find the situation of Artsakh. And as international law is made by practice, unfortunately, if we look at what the United Nations consider as non-self-governing territories, unfortunately, you can maybe go a little bit down, thank you. So you find exactly all the territories which are today on this list. In fact, in the past, the UN General Assembly several times did not follow exactly what the states said when they gave their list. For instance, France considered that Algeria in the 50s was just an overseas department. It was not a non-governing territory. If you look at Portugal, Portugal considered that its overseas territories were provinces. They were overseas provinces, not non-self-governing territories. For that reason, the UN General Assembly, from an authoritative and authoritarian point of view, decided to put on the list territories like Algeria or like the Portuguese provinces. The General Assembly did the same with, for instance, the Spanish provinces, which were not only were not also on the list. And recently, quite recently, they did the same with the French Polynesia, in spite of the fact that during the last elections in Polynesia, which is a territory, an overseas territory according to the French public law, in spite of the fact that in the last elections in French Polynesia, the independentist party did not get the majority. It was a classical party who got the majority, and not the independentist party. So you see that in spite of this fact, it did not prevent the General Assembly from going further than what elections show in the particular case of the Polynesian situation. But today, there is an evolution of the self-determination principle. Both speakers, which were before me, referred to the Kosovo case before the ICJ, when the General Assembly asked an advisory opinion to the International Court of Justice according to the legality of the unilateral declaration of independence in respect of Kosovo. And the court, as always, very carefully confines itself just to say, well, such a declaration is not contrary to international law. But in fact, the ICJ did not say anything about the legality of the secession of Kosovo. It just said that the declaration itself is not contrary to public international law. Now, if we look at the resolution on friendly relations, the well-known 2625 declaration concerning the principles of international law concerning friendly relations and cooperation among states, it is stated, and everybody knows that the fifth principle of this declaration, the seventh paragraph, states that nothing in the foregoing, I quote, nothing in the foregoing paragraphs shall be construed as authorizing or encouraging any action which should dismember or impair, totally or in part, the territorial integrity or political unity of sovereign and independent states conducting themselves in compliance with the principles of equal rights and self-determination of peoples as described above, and thus possessed of a government, and that's the important words which are often used in order to plead in favor of a right of secession, thus possessed of a government representing the whole people belonging to the territory, unquote. And that's the reason why it is highly disputed, the fact that the peoples who are not really represented by a government could have a secession right. This question was already asked to the Canada Supreme Court, and in the decision of the Canada Supreme Court, the court said that failing to comply with this requirement of representation of the whole people of a territory, the fact that failing to comply with this requirement of full representation of the whole people, that could justify a right to secession. It was the judgment which was given in August 1998. But the court added that it was not sure, the court was not sure that such a rule existed in public international law. And it's interesting to see that, in fact, even if the international practice does not seem to consider that the secession of a territory from a state would be incompatible with the right of self-determination. However, for example, concerning the referendum which was organized in Sudan in 2010 about the future status of South Sudan, the Security Council said that, in fact, in a resolution which was adopted in 2010, it was resolution 1945, that I think that I have the reference a little further in my outline, that the Security Council, in the preamble of the resolution, said, I quote, reaffirming its commitment to the cause of peace throughout Sudan, to the sovereignty, independence, unity, and territorial integrity of Sudan, to the full and timely implementation of the final phase of the comprehensive peace agreement, including efforts to make unity attractive, and a referendum to determine the future status of the people of Southern Sudan in exercise of their right to self-determination. Emphasis
Professor
added.
David, you have 1 minute.
And recalling
left.
the importance of the principles of good neighborliness, etc., etc. What is important is the fact that the Security Council recognized in this referendum a kind of exercise of the right of self-determination. And in my view, it is something which is quite new in international practice and which is quite important. It's really a step forward in order to say that, in fact, the right of self-determination is not only confined to colonial and paracolonial situations, but it could also apply to other situations, as this example of the Sudan situation shows. But the real problem is that in the case of Sudan, this exercise of self-determination, which was recognized by the Security Council, was due to the fact that there was an agreement between the representatives of Sudan on the one hand and South Sudan of the other hand. In other words, if you want to apply this practice to the case of Artsakh, I'm sure that we can plead that there is a right of self-determination in favor of the peoples of Artsakh, but on the basis of an agreement. I think it's maybe something very difficult to find, but in the basis of an agreement between Azerbaijan authorities and the people or the representatives of the people of Artsakh. It's, in my view, the actual state of international practice in the case of the self-determination, even if I perfectly understand the political view concerning the situation in Artsakh. And of course, I completely share the condemnation of all violations of human rights and international humanitarian law which have been committed by Azerbaijan in Artsakh. I thank you for your kind attention.
Thank you I was like enthralled with all of these presentations. It's such a hot topic, obviously. I'm going to turn off this timer. We have a few questions. Someone sent a question that actually overlaps with one that I have, and I hope that I can start it. This question was directed to Dr. Babaian, but I would like to hear from all three panelists on this. Azerbaijan pushes the idea that people of Artsakh have the possibility to exercise their will in Armenia and that they don't need a second state to do so. I will combine this with my question. What would you say then to those who argue, especially in diplomatic circles, and I think that on some level, Dr. Babaian's presentation covered the factual basis for this, but still, how would you respond to those who say that Armenians need to give up their dreams of secession, or at least, give internal self-determination a try, or give Azerbaijan a chance to show that they will keep their promises of respecting the right of Armenians? And, because, say, circumstances are not what they used to be before 1988, and only failing that can external self-determination be an option? What would you say to that?
Yeah, thank you very much to the question. I mean, I would say from seeing the history and everything what just happened in 2020, I mean, we saw that Azerbaijan is not granting the right to internal self-determination. So I think we overstepped the point to say, okay, let us try again. Because, I mean, what they really want and what the intention of Azerbaijan is to really, I mean, to say, like, nullify, not annihilate the Armenian population. So I don't see any chance, because of the intent, also from Turkey, which they renewed again in their speeches, and they said they want to continue with what their fathers did in the genocide. I don't see any kind of solution staying within the realm of Azerbaijan, on the territory of Azerbaijan.
Thank you. Karnig, do you have something to say about it? I'm sure you do.
Thank you. I think that...
Oh, we can't hear you. Hold on.
Can you hear me now?
Yes, thank you.
On that, I think that I think I have a general displeasure with the idea of internal self-determination, because I do believe it is a more recent construct, and was created in a way to try to split the hair, that is really at the crux of all our discussions today. And I think with respect to the Artsakh situation, not only would it be a travesty, but it borders on absolute willfulness if the international organization, international community were to essentially strong arm an internal self-determination solution to Artsakh. I think that would be, let's pretend that the war didn't happen. We have an entire century of we have an entire century of conduct vis-a-vis Armenians by Azerbaijani authorities that tells a completely different story. I mean, the only possibility is willful blindness if we just pretend that those don't exist. If we pretend the entire century didn't exist, then you could drive and you could live in an the issue is not coexistence either. I want to be clear on this. This is about authority. It is about governing authority over the Armenian people, and that's where the issue comes out. And I think that it would be beyond travesty. It would be only willful blindness can put us in a situation where this is acceptable, because we either have to turn our backs on the last century of history, and buy a pipe dream that the regime is different. And in order to do that, we're literally going to have to close our ears to what we're hearing from Baku yesterday, the day before, and pretend that even the ICJ order doesn't exist. The ICJ order was very clear on what kind of hate speech rhetoric was coming out of Baku, and there you have an impartial panel making a decision that the hate speech that is emanating from Baku is coming from the highest levels of the state apparatus, not from somebody with a Twitter profile. I mean, it would be unconscionable to allow that to happen for the international community to force that solution. I don't see that as a reality. I think that's a pipe dream that will result in one of two things: Azerbaijan's completion of its ethnic cleansing by forcing the population to leave, or slaughter. And I think anybody can see that. I would be shocked if the only people that don't see that are people that are not following what's on the ground every day.
Thank you, Karnig. Professor David, do you have anything to contribute?
Yes, I consider that in fact diplomacy is always better than a war. The maxim. I think it's Benjamin Franklin who said that a bad peace is always better than a good war. Anyway, as I'm a deep pacifist, I am for diplomacy, of course, but the limits of diplomacy, you can see that now with the Ukrainian situation, of course.
True. It is a hard one, because it's hard to get the diplomatic or the international community to see things the way that you guys are presenting them. And I've said this before, that if the result of pushing this forward ends up being that the Armenians of Nagorno-Karabakh feel that they have to leave, that they don't have a choice, that is tantamount to ethnic cleansing, because they're not choosing to leave. They feel they have no choice. Let's see. Next, I'm like becoming a co-panelist. I'm not supposed to do that. We have another question. Wait a minute here. It's to all panelists. If there's no clash between territorial integrity and self-determination, what will happen if the Republic of Armenia recognizes the territorial integrity of Azerbaijan now? How will this impact the remedial secession process? I think it's just, because we know that there are talks about this, and it scares a lot of people. What are the consequences if Armenia does recognize officially the territorial integrity of Azerbaijan, and how do you think this can impact the remedial secession process? Maybe Professor David, you want to take this? It's for all panelists.
Yes, thank you. I would be surprised that Armenia recognizes the territorial integrity of Azerbaijan if we consider that the Artsakh is a part of Azerbaijan. I'm sure that if something like that would occur, I suppose that it would be a real governmental crisis in Armenia. So I'm not sure that it's possible, of course, for Armenia to recognize such an territorial integrity. And I perfectly understand this refusal to recognize such a territorial integrity, considering the fact, and you know, in general, I am very legalistic, but I had a look, I don't really know the history of Artsakh, but however, I had a look at a glance on Wikipedia, which is my my main source of knowledge today, and it's true that it's quite clear that Artsakh is a part of Armenian statute, Armenian population. So it's something it's difficult to dispute, of course. But you know, if we take the problem, if we take the historical point of view, we are trained, we are triggered to very difficult questions. Look, for instance, what Israel said about its historical links with the territory, with the Palestine territory. So you see, it's a very dangerous path to follow this kind of reasoning.
Thank you.
Yeah, I mean, what shall I say? I'm totally with Professor David. And I mean, I heard of rumors that Armenia is going to do this. I hope they are not going to do this because, in my opinion, it's a kind of judicial suicide. I mean, maybe you can say we are respecting the territory from the outside, but in between, still, there is us, and it is Nagorno-Karabakh. And as we know, it never should have been implemented into the Azerbaijani SSR at that time. So, and it was like 98% were Armenians. So hopefully they don't do that, because I don't see any kind of sense. It's not even from a diplomatic sphere. It's not even tactical, logical. So I hope that's not going to happen.
Karnig? I know that Karnig and I have had this discussion, so I kind of know what he's going to say, but I think the crowd would like to hear from you. Oh, did he freeze? No. Yeah. Okay. Should I become a co-panelist again? No? Okay. Just in time. Karnig? Did you hear us? Okay. Karnig, wait. What would happen if Armenia recognized the territorial integrity of Azerbaijan? Would this hurt the remedial secession process? I don't think he's with us anymore. Oh,
I'm here now.
okay.
I didn't hear the question though. I'm sorry, Sheila.
What would happen? What would happen if Armenia recognized the territorial integrity of Azerbaijan? Would that hurt the remedial secession process?
Well, that's an interesting question. I guess I didn't hear the other respondents' answers, but I think from just a purely legalistic standpoint, would it have consequences and implications? I think that it would. I think that it, especially given the fact that statements by heads of state have, the head of state in Azerbaijan has already essentially assumed what that means and has made public statements on that, which, you know, I mean, the questions of estoppel and waiver come into play to determine whether or not any carve-outs are made or any in any of Armenia's statements. Again, that's from from a purely legalistic standpoint, what that statement says is what kind of governs, right? I mean, what the actual language is. We don't know what that language, I don't know what that language looks like, and I don't know who does. Would it have an impact? I would say that it would, depending on what the language says, and if there's a particular carve-out that reflects the fact that the status of Artsakh is still unresolved, or it's not. You know, who knows what that statement is going to say? I don't know. Or if there is a statement, I don't know. I'm not a I'm not a fortune teller to be able to tell what the actual wording of any such statement is, but I can assure you, statement comes out in order to carve out status issues. I don't know if that was something repeated by others. I repeated others' responses, so I apologize for that because I didn't hear the initial relay.
Oh, no, that I don't think that that came up, and I do agree with you in that it depends on what in practice such a statement will mean, because there is no, to my mind, there is no tension between recognizing the territorial integrity of a state and affirming the right of self-determination of the people within that state. There's no conflict there, unless, of course, the mother state wants to see one. So, yeah.
Well, I think that there is, sorry to interrupt you, Sheila, but there is one right now that's at play, right? I mean, I think that statements by Aliyev have made clear as to what his interpretation of that, any such recognition would be. I mean, so, you know, other kind of equitable principles come into play at international law, being, you know, that's a statement made and there's no response made to that, then we have, you know, I think it's a complicated question, you know, and it's a different question, you know, it's a complicated question based on language of particular statements. And we can't hide the fact that the reality in the public discourse from Azerbaijan is that that type of recognition means that everything is included in Azerbaijan. And I think, I mean, I don't have Aliyev's statement in front of me, but I think he's on a number of occasions that he's pretty clear that that's what his interpretation is.
Thank you so much. This was one of the, in my opinion, best panels so far. And yeah, that's it. I think we can take a break now. Am I wrong? Yeah.